Hello students, my name is Liz Attia and today's topic is the defences to negligence. So, defences to negligence and the role of the insurance company. So you'll remember we actually said that the elements of negligence are a duty of care, that there is a breach of that duty, that the breach of the duty resulted in the damage and that there in fact is damage. Contributory negligence is actually a defence to negligence, and that's the argument where if proven, the defendant might actually claim that the plaintiff, as a result of their inaction or action, contributed to the outcome or to the damage which was actually sustained. And if contributory negligence is in fact proven, then what you'll actually find is that there is the damages are apportioned between the percentage of blame by the plaintiff's own action and the defendant and their failure to act prudently or reasonably given the circumstances. The second defence to negligence is the voluntary assumption of risk. And in fact, there aren't many cases in Australia where voluntary assumption of risk has been used. However, it is a complete defence if used successfully, and it would in fact preclude a plaintiff from obtaining any recompense at all. Voluntary assumption of risk is if the defendant can demonstrate that the plaintiff voluntarily and knowingly assume the risks inherent to the dangerous activity in which they were participating at the time of injury. So it might be those circumstances where a doctor would in fact advise against a procedure, or a health professional would actually say, listen, the risks are too great, we wouldn't advise it, it's against our judgment, and the person still indicates in writing that they want to go ahead and proceed with the intervention. On those circumstances, it would be at law quite permissible to actually say, well, the client or the plaintiff voluntarily assumed the risk, having been advised of the disproportionate benefits of the intervention or the treatment. So I guess the other exception to draw your attention to is the Good Samaritan legislation. So the Good Samaritan legislation is actually section 56, 57 of the Civil Liability Act, and it was to cover those circumstances where in New South Wales people, a health professional in particular, would actually attend or assist in an emergency and then something go wrong, and what legal liability or exposure to risk they might then be opening themselves up to. So a further defence is for those who attend an emergency and provide substandard care under this Civil Liability Act. So claims of negligence, there is in fact complete immunity for civil law claims in these circumstances, noting that the competence of the professional providing the assistance, so as long as they're not actually under the influence of drugs or alcohol, or their capacity is not compromised in some way, will actually have immunity for civil law claims against them under this particular legislation. And like I said, where it came about is in an attempt to ensure that health professionals felt that they were able to render assistance in an emergency without exposing themselves to some legal liability if things were to actually go wrong. So what's the role of insurance companies in these negligence claims? So when a claim is actually made by a plaintiff for financial loss and or treatment regarding medical malpractice, in most cases it's the insurance company, the practitioner or the health agency who would compensate the claimant. So depending upon the policy document and the particulars of what's actually covered in that insurance policy, negligence would actually be the professional will be indemnified against individual action, and it would be the insurance company who would foot the bill there. So all practitioners are required at law to have professional indemnity insurance, and that's whether you're actually as part of an agency or whether you work individually as a sole trader in your own business. Clearly, if it's your own business, you'd have to take that out privately. If you actually work as an employee with an agency, then the employer would take that out on behalf of their workers. Do note, however, that most policies will actually have a clause that if the practitioner was reckless in their performance of their duties, that the policy would not cover them. So don't automatically assume that because there is professional indemnity insurance that absolves you as a health professional of any personal liability. Most policies will actually have a clause that if there is a breach, a reckless breach based on not following protocol or process, then the professional wouldn't in fact be covered in those circumstances. So it's to ensure that people obviously take their individual responsibilities very seriously and don't just become complacent on the basis that their insurer will cover any claims that might arise if they're not performing their duties properly. Thank you, students. That brings today's topic to an end.